Okay, cool. Oh, here, let me make this a little bigger for you. All right. So a listing agent works for the seller. A buyer's agent works for the buyer. Which responsibility does a licensee have to the other agent's party? Is that A, must treat all parties to the transaction honestly and fairly? B, keep the other party's confidential information from his own principal? C, owe the first duty of allegiance to the other party? Or D, no responsibility is owed to another party as agents' duties are owed only to their principals? And I will go ahead and copy and paste and put this in the chat. Only my, there we go. All right, we got A. Cool, exactly, yeah. A. So it's going to be must treat all parties to the transaction honestly and fairly. Good job. Next question. An agency relationship created through a listing contract can be terminated by the A, seller's or broker's death, B, buyer principal renouncing the agency relationship, C, agent executing a buyer agency contract, or D, agent discarding the agency disclosure form. Oh, I copied and pasted and it just randomly shows. Any guesses? All right. A and A is correct. Good job. So a listing agreement can be terminated upon either the seller or the broker's death. Okay, good job, Ed. An agency relationship created through a listing contract can be terminated legally without recourse under which circumstance? So basically the last question. But A, when the salesperson becomes mentally incompetent, B, when the buyer dies, C, when the listing broker dies, or D, when the listing salesperson dies. Michael, can you grab my phone? Grab my phone. And just like whatever copy and paste and put it in that. Okay, can you just put it on wherever you said copy and paste, put it and send it in that group chat. Thank you. All right, we got C, and C is correct. Good job. So just like the last one, it's going to be whether the listing broker or the seller passed away. Okay, next question. S&T Realty had a listing on a property. After the property sold and closed, P&M Realty asserted its rightful claim to the commission. Which type of listing did P&M Realty have? A, open listing, B, exclusive listing, C, exclusive right to sell listing, or D, net listing. And definitely knowing the differences between these is going to be super helpful for the exam. All right, so correct answer is going to be A. And A is open listing, and only the procuring broker is entitled to commission in an open listing. These are confusing because open listings aren't a thing in Ohio. Neither are exclusive listings or net listings. We only do exclusive right to sell listings. But Open listings are probably going to be the least common, and those you still get a commission. Same thing with exclusive right to sell. But the procuring broker is the one who gets the commission for the open listing. Okay, and then the question rationale definitely gives a better breakdown of the differences between those. Okay, so a licensee has secured their first listing contract. The licensee most likely is considered a blank agent. The licensee most likely is considered a special agent, a B universal agent, a C general agent, or a D limited agent. Sorry, I copied and pasted, but ignore my little bubble wherever it goes. All right, we got D general agent. Oh, I thought it was gonna be general agent too. So it is a special agent, and a special agent is committed to doing one thing for a client. Example, marketing the home. Got it. A general agent does more than one thing, but not everything for a client. Example, a property manager. Okay, cool. So the question rationale is very helpful in differentiating between all four. Okay, yeah, that was a good guess. I also thought. So basically, the licensee is a special agent, so you guys are going to be special agents. Brandon lists a property. Brandon finds a buyer. Is Brandon allowed to write an offer as a buyer's representative? A, yes, as long as both parties agree to it in writing. B, no, an agent cannot collect both commissions. C, no, it's against federal trade laws. D, yes, if it is specifically written in the offer. All right, any guesses? D? I was gonna say D or A. Okay, so it is A. So as long as both parties agree, that Brandon list is the listing agent as well as finds a buyer, as long as they both sign the contract, then informed consent is required for dual agency. Yeah, that was a tricky one. Okay. Which of the following factors would be most significant in deciding whether a broker was acting as a buyer's agent? Is that going to be A, the buyer signed an exclusive representative, wait, a buyer signed an exclusive representation agreement with the broker? B, the broker showed the buyer properties listed by cooperating brokers? C, the buyer paid a commission to the broker, or D, the broker assisted the buyer in securing financing for the property being purchased. So the most significant. A was the correct answer. So the buyer signed an exclusive representative agreement with the broker. Both are good. Both are good. answers, but the best one is going to be A. Go with your gut. And I know it's easier said than done, but A was the correct answer. And so, yes, so anything that says you get signed or you have both permission is most likely going to be the best answer. Which is the best example of a general agent? An A, property manager, a B, a real estate agent, C, power of attorney given specifically to transfer an automobile, or D, universal power of attorney. So based on the previous question, which one is the best example of a general agent? You said A first, and that is correct. A is the best example of a general agent. Good job. Next question, which is the best example of a special agent? Is that going to be A, a limited agent, B, a property manager, C, a real estate licensee, or D, a universal power of attorney? And C is correct. Good job. So definition of special agent is one who has very limited authority and may do only one thing for the principal. Example, find a ready, willing, and able buyer. So an example of a special agent is going to be real estate licensee. All right. A listing broker tells the buyer client that the seller is anxious to sell because they are delinquent in their mortgage payments and do not want the property to go into foreclosure. Such a disclosure is A, required because the broker is also the agent of the buyer, B, only permitted if the mortgage lender authorized the disclosure, C, acceptable if it results in an offer and quick sale of the property, or D, unacceptable because of the fiduciary duty owed to the seller. All right, I'll give you guys a good minute to read this because this is like loaded question. Any guesses? Or anybody know the answer? Whatever you feel, don't be afraid to guess. I forget a lot of these as well. All right, got B. Okay, so the correct answer is going to be D, which is unacceptable because of the fiduciary duty owed to the seller. Got it. So the fact that the property owner is delinquent is information considered confidential under an agent's fiduciary duty. Yes, so anything that is related to privacy and specific to either a seller or buyer's like personal things going on definitely can't be shared amongst seller or buyers, but only to their agent. Okay. Cool, good job. Those are tricky ones. I feel like they're always changing. All right. I'm just gonna scroll and just feel free to put in the chat whatever other topic you want to go over today. Anything in particular? Mm. All right, practice of real estate sounds good. Well, okay, first question. Broker Greg, who represents a seller under an exclusive listing agreement, receives two offers for the seller's property at the same time. One from an agent in his office and one from the salesperson of a cooperating broker. What should the broker do? Is that A, submit the offer from his agent first and let the seller decide on it before looking at the other offer? B, submit the offer from the cooperating agent first and let the seller decide on it before looking at the other offer? C, submit the higher offer first. If it is not acceptable, look at the other one. Or D, submit both offers at the same time, allowing the seller to make a decision after looking at all the facts. All right, D. And D is correct. Good job. There is no written rule about the order to present offers in most states. However, the seller has the right to know all the facts and look at all the offers before reaching a decision. All right. Next question. In the 1968 landmark U.S. Supreme Court case of Jones versus Alfred H. Mayer Co., it was ruled that A, state law shall have precedence over the Federal Fair Housing Act. B, sexual preference is now a protected class in fair housing laws. C, racial discrimination in the sale of any property is prohibited without exception. D, the Fair Housing Act is void. All right, we say B. All right, so yes, it is C. Racial discrimination in the sale of any property is prohibited without exception. Exactly. All right, good job. It is C. Next question. A real estate agent knows of a defect in a listing property but fails to tell the buyer the agent is guilty. of A, negligence, B, fraud, C, nothing because the agent is looking out for the seller as they should be, or D, misrepresentation. All right, we say, so it is, I couldn't remember if it's B or D, so it's going to be B, fraud. So real estate agent knows of a defect in a listed property but fails to tell a buyer, and that is going to be B, fraud. Fraud is an intentional lie or intentional misrepresentation. And then misrepresentation is going to be negligence. So the question rationale is super helpful in knowing the correct answer and definitely going to be helpful for the test. A broker or salesperson refusal to cooperate with the other brokers because of race is prohibited by the A, Presidential Fair Housing Act of 1973, B, Executive Order of 1068, C, Federal Fair Housing Law of 1968, or D, Civil Rights Act of 1844. All right, we say D, and it is going to be B. And they're just trying to trick you because it's Civil Rights Act of 1844, but it's really 1866. And the Federal Fair Housing Law of 1968 covers discrimination by sellers and salespersons or brokers, and discrimination based upon race, color, religion, sex, national origin, disability, and familial status. That was a super tricky one. Honestly, I thought it was going to be C or D, but when it comes to federal fair housing and involving salespeople and brokers, know that that's going to be the Federal Fair Housing of 1968 involves brokers and salespeople. Yeah, that was a tricky one. A seller who lives in a small town has posters made up advertising their house for sale. They post them on many telephone poles around the neighborhood. As part of the poster, they advertise that they will pay 3% to any broker who brings them a buyer. This type of listing is A, an open listing, B, an exclusive right to sell listing, C, switch of agency agreement, or D, nut listing. This was tricky. All right. It is correct. It is an open listing. When a seller offers a commission to any broker who finds a buyer, this is known as an open listing. The seller does not sign exclusively with any one agency. All right, next question. A broker reads in the local newspaper that a seller is advertising a property for sale by owner and is offering 3% to any broker What type of listing is a seller offering? So a broker reads in the local newspaper that the seller is advertising a property for sale by owner and is offering 3% to any broker. What type of listing is the seller offering? Is that an A, exclusive right to sell listing, B, open listing, C, switch of agency, or D, net listing? Yeah, this is a tough one. And you're correct. It is going to be B, open listing. The seller is making an open offer for any broker to find a buyer, but is not willing to sign exclusively with one broker. Exactly. Good job. Under the Federal Fair Housing Act of 1968, it is permissible to A, tell an individual that an apartment has been rented when in fact it has not. B, alter the terms of a loan for a member of minority. C, advertise property for sale only to a special group. D, refuse to give a loan to an individual because they have a poor credit history. All right, good job. It is going to be D, refuse to give a loan to an individual because they have a poor credit history. All right, next question. When is a broker agent entitled to commission? Is that A, when a ready, willing, and able buyer is found on terms acceptable to the seller? B, at the closing table? C, when the listing agreement is signed? Or D, when a sales contract is signed? One's a little bit tricky, but which one is the best answer? So it's gonna be, I don't know, you say B? So it is A. When a ready, willing, and able buyer is found on terms acceptable to the seller. So a broker agent is entitled to commission only after fulfilling the duty of finding a ready and willing, able buyer on the seller's terms. So when a broker or an agent finds a buyer for the property, that is when he is entitled to commission. He or she is entitled to commission. All right. A sales agent leads a sales agent reads in the local paper that a seller is offering property for sale by owner with a 3% fee to any broker who brings in a buyer. The agent asks to show the property to a buyer. Which type of listing has the seller offered? Is that going to be A, exclusive right to sell listing, B, open listing, C, exclusive agency agreement, or D, net listing? And B is correct. It is an open listing. Well, they really do like the term open listing. Okay, good job. Now we know the definition of every which way it's an open listing. So a real estate licensee needs to have a broad understanding of law and how it affects real estate. B, legal experience as a practicing lawyer. C, little understanding law because competent attorneys are available. Or D, an in-depth understanding of constitutional law. That's actually a great question. I don't know. I'm pretty sure A. Yeah. Okay. Good job. It is going to be A. Real estate licensee needs to have a broad understanding of law and how it affects real estate. Exactly. Even though your classes and these questions make it seem like you need to know everything about law, you just need a broad understanding of it. Okay, which is not an element in an action for fraud? is that A, there must have been an intentional misstatement of fact. B, the defrauded and defrauding parties must have relied on a confidential relationship. C, the statement of fact must have been a material misstatement of fact. Well, these are confusing to read. Or D, the defraud party must have been entitled to rely upon the misstatement. So definitely when you're taking your exam, read through each question. And you could read it several times, or each question and every answer until you completely understand what they're asking, because they will try to trick you by making up words or scenarios. Or like you saw, changing the years on some of the Civil Rights Act or Federal Fair Housing. So which one is not an element in an action for fraud? So fraud is going to be intentional. These are confusing. I want to go with, yeah, let's try. Okay, so it is B. So let's see what they're reasoning. So B is going to be the defrauded and defrauding parties must have relied on a confidential relationship. So there is no requirement that the two parties have relied on a confidential relationship. There is no confidential relationship between a buyer and seller, but a buyer may maintain an action against the seller for fraud. Right, that was just a terrible question and answer. But yeah, that was very confusing. Which type of listing is most desirable from the point of view of the broker? Is that A, exclusive agency listing, B, net listing, C, open listing, or D, exclusive right to sell listing? So which type of listing is most desirable from the point of view of the broker? And so it is actually going to be D, exclusive right to sell listing. And that's going to be the most desirable because the seller relinquishes all rights to market and show the property to the broker. The exclusive agency listing will gain the broker commission only if an agent, not the seller, finds the buyer. So exclusive right to sell listing, even if the seller finds the buyer, the broker will still make commission. But then exclusive agency, if the seller finds the buyer, the broker is not entitled to commission. So that's going to be the difference between the two. All right, a salesperson presents a full price offer from a financially qualified prospect who is Black. Later, the salesperson's broker presents a lower offer to the same seller from a prospect who is white. The seller accepts neither contract but sells to a neighbor through the same salesperson and broker who decides to buy the house to prevent the prospect who is Black from purchasing the property next door to him. Which party would not be subject to liability under the Federal Fair Housing Act of 1968? That can be A, prospect who is white, B, salesperson, C, seller, D, neighbor. A long question. All right. There's going to be A, and A is correct. No person is allowed to be a party. No person is allowed to be a party to plan of discrimination. Yeah, good job. So that fully loaded question and the answer was a parent. So the term caveat emptor literally translates as there is a hole in the exterior. B, Caesar is emperor. C, let the buyer beware. Or D, long live the king. Well, hopefully this one's on the exam. All right, is C. Yes, let the buyer beware. Good job. Sellers negotiate a listing with a broker stating that if they find their own buyer, they can save the commission. However, if the broker, their agent, or any other broker firm finds the buyer, then the sellers will have to pay the broker's commission. What type of listing did the sellers and brokers just negotiate? That A, open listing, B, net listing, C, exclusive agency agreement, or D, exclusive right to sell listing. All right, good job. Yep, it is going to be C. That is the exclusive agency agreement. Again, just knowing these for the test and knowing the difference is going to be super helpful. But then after that, exclusive right to sell is going to be the only thing you'll need to know. Okay, cool. All right, I think I have time for a quick one more. Okay. I know that. Let's do transfer to title. Transfer of title. This is 5 questions that we could buzz through. Oh, there we go. Okay. The open, notorious, hostile, and uninterrupted possession of the property of another under claim of title is called A, easement by necessity, B, acceleration, C, adverse possession, or D, easement by prescription. All right. Good job. It's going to be adverse possession. You always remember this one for those ladies. All right. An abstract of title is A, sworn statement that title is good. B, contract whereby a title insurance company indemnifies the owner against loss due to defects and hidden risks on the title. C, chronological summary of the essential provisions of every recorded document pertaining to a particular parcel of land. Or D, written declaration by a person executing an instrument signed before an officer authorized to give a note. All right, good job. It is C. So chronological summary of the essential provisions of every recorded document pertaining to a particular parcel of land. Very nice. Next question. Real estate taxes are prorated as of the day of closing. The real estate taxes are A, debit to the seller and credit to the buyer. B, debit to the buyer and credit to the seller. C, credit to both the buyer and seller. D, debit to both buyer and seller. This is going to be definitely super helpful to know on the exam. So it is going to be A. This was a tricky one. So the buyer is going to be given the credit for the taxes and it's going to be a debit to the seller. So real estate taxes are a debit to the seller who must bring the taxes current up to and including the day of closing. They are credited to the buyer when taxes are prorated between the two parties. That way, when the buyer goes to pay taxes the following year, the buyers aren't gonna have to pay from, let's say, January to April. They'll just cover, because the house closed in April, they'll just cover April to December. So the sellers cover the first half of the year. So it's gonna be a debit to the buyer and a credit to the seller, or no, I'm sorry, debit to the seller, a credit to the buyer. Okay. Which statement concerning a settlement or closing statement is true? A, the real estate agent's commission is a credit to the buyer side of a closing statement. B, there is a corresponding debit for a seller and credit for a buyer for all changes on a closing statement. C, there is a corresponding credit for a buyer and debit for a seller on all charges on the closing statement. D, a closing statement is a simultaneously listing of debits and credits to the respective buyer and seller. All right, D, and D is correct. Good job. So it is going to be a simultaneous listing of debits and credits to both the buyer and seller. Yeah, good job. And last question, who executes a deed? Is that an A, a grantee, B, a notary, C, a grantor, or D, a vendee? Correct, good job. So who executes a deed? And that's going to be C, a grantor. All right, good work.